order restraining the respondents from implementing those orders. And then there was a prayer for the calling of the file in the court in its supervisory jurisdiction should call for the file, Milimani file number E1348, and peruse and make directions as appropriate as to those orders. And then there was a prayer for the calling of the file in the court in its supervisory jurisdiction should call for the file, Milimani file number E1348, and peruse and make directions as appropriate as to the calling of the file in the court in its supervisory jurisdiction should call for the file, Milimani file number E1348, and peruse and make directions as appropriate as to should call for the file, Milimani file number E1348, and peruse and make directions as appropriate as to and peruse and make directions as appropriate as to an order of certiorari for purposes of calling to this court and quashing the orders of 8th May 2023. So then it's manifest that the prayers that were sought in the interim, that is A, B, C, and D, have been overtaken by events to the extent that they were sought of 8th May 2023. So then it's manifest that the prayers that were sought in the interim, that is A, B, C, and D, have been overtaken by events to the extent that they were sought, that the prayers that were sought in the interim, that is A, B, C, and D, have been overtaken by events to the extent that they were sought, that is A, B, C, and D, have been overtaken by events to the extent that they were sought. Now, counsel for the petitioner are only too aware that such an order, being a substantive dispositive order, can only issue after full consideration of the merits or otherwise of each party's case. The Court of Appeal pronounced itself hearing and at the end. And the court would not be able to vindicate the course of justice. In the case of Ashok Kumar Bajpai versus Dr. Baipai, at reasons for passing such an order and make it clear as what are the special circumstances. So then, even assuming that such an order would be met in the circumstances of this case, the petitioner is hereby invoking the supervisory jurisdiction of the court under Article 165(6) and 7 of the Constitution and Section 362 of the Criminal Procedure Code, which entails disparate and distinct procedures. One of the applicable rules for consideration would be High Court Organization and Administration General Rules, which provides in Rule 20 that subject to the practice directions issued by the Chief Justice, the filing of appeals, bail applications, and references from subordinate courts, tribunals, and other bodies or authorities within regions designed under the schedule shall be made to the respective High Court Station Registry with corresponding supervisory jurisdiction according to established judicial administrative regions set out in the schedule. Now, 2 says that despite 1, the supervisory jurisdiction of the court over subordinate courts and over any person, body, or authority exercising a judicial or quasi-judicial function as contemplated by under Article 165(6) of the Constitution is not limited. And in particular, the court may call for the records of any proceedings before any subordinate court, body, or authority exercising a judicial or quasi-judicial function and make orders to ensure the fair administration of justice. So according to the schedule, to the rules, the High Court Station with supervisory jurisdiction over Milimani Chief Magistrate Court would be High Court the High Court at Milimani, Nairobi. It is therefore anomalous for the petitioner to seek to invoke the supervisory jurisdiction of the magistrate court in the manner proposed in the second application. And I've noted that whereas the court has powers under sub-rule 2 to entertain such an application, the good cause would have to be shown for any departure from the requirements under 1. No such cause has been shown, and certainly it was not contemplated that such proceedings be called for by way of a notice of motion in a constitutional petition such as has been done here. So I therefore take the view that the second application is entirely misconceived and therefore untenable, and that if anything ought to have been brought by way of revision in a separate cause of action. So having taken the view that for purposes of section 362 of the Criminal Procedure Code, the impugned order ought to have been challenged by way of revision before High Court at Nairobi, I must refrain from commenting on the correctness, on the legality or the propriety of the orders of the magistrate in application E1348 of 2023. Of course, as pointed out by counsel for the respondents, other avenues open in the circumstances would be a review before the magistrate himself or an appeal from the decision of the magistrate. So in the light of the foregoing, the orders that commend themselves to me and which are hereby grant are as follows. A, that other than prayer G, the rest of the petitioner's prayers in the notice of motion dated 3rd May 2023 fail and are hereby dismissed with no order as to costs. B, the second application dated 8th May 2023 being misconceived is hereby struck out with no order as to costs. So that is my decision. Yes, Mr. Ombeta? Mr. Omari. Please raise up your voice. Certified copies. Okay. I believe you've spoken on behalf of everybody else on your team. So let's hear Mr. Makuto. Yes. Mr. Omari has pointed out, and correctly so, that the court needs to give directions on the petition. Have you filed your responses? So here are my directions. One is that council concise will be supplied with a copy of ruling. Counsel for the petitioners will be supplied with a certified copy of the proceedings as well. And I've directed that responses to the petition be filed within 14 days from today. I will take a mentioned date shortly for further directions. Can I have a date? We have the 29th of May. So further directions.
We have leave file in the event after we have seen this. Also, secondly, the second report. And pursuant to the court's ruling, shall be seeking to amend the petition so that it is in time. The ruling direction.
to leave to amend being granted, but we needed clarification as to how long the petitioners would take to amend their petition, because it will affect the timelines.
Yes. So, Mr. Omari, you have 7 days to effect the amendment. So you will still maintain the 14 days of the response and how many staff, 7 days, you still will be able to respond to those standards. That means the responses will only be filed after the start.
The Urban Commissioner will maintain it to the measure.
Okay. Dorothy, work it out again. So we are talking of 7 days within which to amend the plaint. Then upon service, you'll have 7 more days, Mr. Makuto. 7 more days. So 14 days will begin to run from today. Yes. So we do not really need to change. Yeah. So 29th of May is maintained for further directions in the petition. So I think that should be it for this matter.